All right, everyone, I'm back. I got a fresh new whole thing. It's dealing with the filing a complaint, but it's based on Chevron deference, based on the SEC, Berkshire Chairman, and it also show you that the county clerk is responsible for everything. Always remember that the county clerk is responsible for everything. But I'm about to break things down to you real quick. So I'm gonna show y'all something. And I want y'all to look at it real quick. First, we're going to look at a sample. We're going to look at a sample real quick. Hold up. I look at a sample. All right, here we go. Now, this is a sample I'm doing right here. Uh, I want everybody to look at this complaint real quick. This is a sample. You can use this complaint for any document, anything that do with violation of fine, penalty, arrest, uh, you can use this right here for repossession, anything. It could be for traffic ticket, CP, how you say, child protective agency, child support. You can use this complaint right here. This is a sample. I made this like a one little sample for everything. So I'm gonna show y'all something. I'll show you real quick so you can look at the complaint. See, like the sample of United States District Court of Eastern District of Texas. Like the government I'm with, like the United States, I just put John Doe complainant and Michael Douglas at the so-called doing business at Turn Revenue at defendant. And see right here, I put right here the complaint as a sample, a complaint. I want everybody to see the complaint real quick. Hold on. So I'm only gonna do like 1 hour on this bad boy. Then I'm gonna shut it down. Then I'm gonna try to come back a little bit more for y'all. There we go. A little bit better. There we go. Here you go. See right here. It's like a sample complaint. Here you go. Come now. The plaintiff of the United States American Republic, John Doe, moved this honorable court. Complainant of defendant Michael Douglas of the Return Revenue within the district of what? 26. The district of 26, Texas, United States House of Representatives District, Michael, and the county clerk. Now, the reason why I did that, if the Return Revenue or the FBI or ATF or EPA or the OSHA or the Department of Labor, Department of Education, whoever, the three-letter agency, state agency, you know what I'm saying? Whoever into that federal district claims to be federal agency, you want to go after the U.S. representative of your district. You know what I'm saying? You want to go after that, and you want to go after the county clerk. So I want you to see this real quick. So, in other words, if the Return Revenue sent a letter to John Doe, within the district of what? 26, Texas 26 district of Congressman, House Representative Michael, then, then might become liable for this action of Michael Douglas. And the county clerk is liable if he or she certified at notice 11. I'm just gonna go through here real fast so you kind of look at the complaint. See, complaint. Then you got the industrial. See right here, I put the action is an action brought by the plaintiff for a violation of the Seventh Amendment, Fair Debt Collection Practice, and the Act. 15 USC 1692, Register a Foreign Agent Propaganda Act. 22 USC 612, 22 USC 615, and the Examination, Certification, Appointment Act. 5 USC 331, 332, 3333, General Probation, Act of 5 USC 302, and the Texas Foreign Entity Section 9.001, and defamation of character, respectively. So, in other words, this is a sample. Where I could take this whole sample and keep the sample what it is and use against any agency that claims to making power, claiming to say I owe them something or you owe them something, I can use this right here. Shut this whole thing down. Here you go. I'm gonna, here you go, party right here. Uh, if you want, you want me to help you do a complaint, let me know. See right here, the venture, right here, the district court, Eastern District of Texas, has jurisdiction pursuant to the Seventh Amendment. With that Seventh Amendment, in that over $20, right? The Fifth Amendment, right? You know what I'm saying? You have right to what? The right to face accusers, right? Now, Fourth Amendment, you got right to be secure. All right, here we go. Right here, Seventh Amendment got what? 15 USC section 1692 again. 22 USC 612. So I'll let you look at this real quick. I ain't gonna go through all of them. But you know what I'm saying? Look, the difference I'm showing that the venue is proper for the occurrence which gives the right to the action took place within District 26 and the state of Texas. So now I'm letting you know it happened in a federal district known as 26 House Representative. And who that House Representative is? Michael, the elector of Republican. Here you go, fraction, you know. I'll let you look at the sample, but I'm just gonna go through it real quick. Here you go. I'm gonna show you something. See, this is a sample right here. See, first cause of action. Again, sample. Right here, first cause of action. 1692 Fair Debt Collection Practice Act. Now, you can use this not only just debt collect, but you can use this to get Internal Revenue Service. You can get this a police officer write you a speeding ticket. You know what I'm saying? You can use this against animal patrol, write you a fine or violate the city code. You know what I'm saying? You can use this against wildlife when they fine you or penalize you. You can use the same thing. You don't have to do it against so-called debt collector. You can use this against Internal Revenue. You know what I'm saying? Look, you can use this against somebody tell you got fingerprint, take a mug shot. You know what I'm saying? You know what I'm saying? Or if an officer tell you that this scientist that said, you don't make guilt, but you're show up for court. You know what I'm saying? In other words, you can use this. This thing is powerful. You can use this against child support. You can use this against child protecting agency taking your child away. That's right. You know what I'm saying? Say like they take your child away because you're unfit. Guess what? Guess what? If they collecting something like your child, wait a minute. You can use this right here. I promise you, you can use this. So I'm gonna try to go real quick with this. I'll show you something. Here you go. Second call violation again. Register Foreign Propaganda Act. In other words, these people, so-called federal agents, these so-called state agents, city agency, that's not elected, but party or apply for the benefit and vacation, paid vacation with these so-called agencies. They supposed to have a bond and an oath, and they supposed to register with the state and with the county. They supposed to register with the U.S. Attorney Office. But I'll get it somebody who want to see it. You know what I'm saying? I'm not going to just give it to everybody for free. Look at that. This is a good sample, man. See right here? I can take the whole thing, tear their ass apart. I could tear them apart with this. Here we go. See right here? Third cause of action. What third cause of action? Examination, certification, and appointment. No word. They apply for the job or be appointed again. They supposed to have an open bond. See, it's like this. If they're gonna use the so-called statutory law by the federal that's been elected or by the state legislature that's been elected, if they're gonna use the city or the county law, then they supposed to have a bond. Cause guess what? If the politician ain't gonna arrest you, but they hire you, guess what? You better have a bond and an oath. And you better be registered. You see what I'm saying? I'm gonna show you again. I go to the fourth cause of action. Government organization employee. Again. Y'all need to look that up, see what that is. You know what I'm saying? I tell you right here. 5 USC 302. What that is? That's Government Authorization Employee Act. Now, Now I'm gonna show you why I use these right here. Cause see right here, I can use this if I get. I say like you get arrested, right? I can use this. I can use this whole violation from violation one all the way down to the last part. This to show you that any document they use, I'm gonna show you right here. Any document they use fall right out of this right here. Any document where it could be, you know, what I'm saying, it could be a court fee. It could be it could be anything like pay child support, or it could pay the city part. You know what I'm saying? It could be anything. You know what I'm saying? It don't have to be a debt collector. You know what I'm saying? You know, you can use this for anything. Let me see. Hold on. I think I went a little bit too fast. There you go. Yeah, first call. See this right here? I want people to understand what this. This is real powerful, man. Y'all just don't understand this. This is real powerful. Hold on. First call to action. I don't know why I can think. There you go. First call to action right here. Oh shit. I might mess that up. There you go. Hold on. There we go. I'm sorry about that. There we go. There we go. See right here? A fair debt collection practice. I'm gonna show y'all something. In other words, if you, I say like you gotta, all right, you know, like a lot of states got toll road, and all of a sudden now you know start getting rid of toll booth, and all of a sudden you know when you drive on the so-called public interstate, and they got the toll booth, something like that, and that camera take picture of your license, and they send you a bill saying you owe 40,000 for riding on Interstate 8, the toll road, right? Well, guess what? You can use this right here. You can use this right here. That's right. You can use that because they're collecting a debt. You know what I'm saying? They're collecting a debt. That's false. You know what I'm saying? And you can use this. I'm telling y'all, you can use this for red light camera speeding. I mean, you know, you can use this for, you know, if an officer writes you a ticket for literacy, you know what I'm saying? You can use this right here again. You can use this against child support agency. You can use this against everything, man. Any agency use a paper and use that paper as a weapon, you can use this. And I'm gonna show you. I'm gonna show you maybe on part two. But when any when any agency, whether it's FBI, ATL, whether it's state police or city police, or sheriff deputy, any agency where it's animal patrol, with whoever, city code enforcer, you know, like the city code enforcer, state code enforcer, something like that, the fire protection agency. If anybody do any letter and that letter attacking you, identify you, and threaten you with fine, penalty, or jail, or seizure, or taking something from you, or hold you liable, you can use this right here. And I'm gonna show you something. But you know we're gonna keep moving because I want to show you something about the opinion about the case of June 27th and June 28th. Two very famous cases. You're gonna know what it is. See right here. See right here. Look, look. I got it right here. Look at it. I want everybody to see this right here. See this? This is the beautiful thing. You know. If you want to see this, if you want me to do you know your complaint, and I'll show you how to file it in the federal court or the county the county. I will show you how to do it step by step. It's simple, you know. Look at this right here. This is good right here for everything, even for arrest. You know what I'm saying? The police officer pull you out of your car, you can use this wonderful thing right here, using that false document. hmm now, you know we about to get to the nitty gritty real quick. Cause I don't want to do no 2, 3, 4 hour video, but I'm gonna make it short. All right, here we go. You know, we're gonna get real down to the nitty gritty, y'all. Let's see, I don't want to go too long on this. You know. All right, here we go. Now everybody remember the case, Chevron Death, June 28th, Lover Bright Enterprise versus Rainbow. that famous case on June 28th right here. We're gonna see what they say right here real quick. I'm gonna show y'all something. We're about to find out real quick.
Supreme Court overrules Chevron, opening door for new tax reg challenges. July 10th, 2024. Timothy S. Schuman. Susan E. Reba. Parisa M. Grease. Samuel J. Preston. Reading time, 8 minutes. Overview. In depth. Authors. Related services and home.
Uh-oh. I believe they're taking too long, If they take too long, I probably gonna have to take over and read this myself. You know, they take too long.
Home. Insights. Supreme Court overrules Chevron, opening door for new tax re. On June 28th, 2024, the Supreme Court of the United States reshaped the federal tax landscape when it overturned the long-standing Chevron doctrine in Loper Bright Enterprises v. Raimondo, number 22 to 451. The Chevron doctrine, a pillar of U.S. administrative law for 4 decades, required courts to defer to an agency's reasonable interpretation of an ambiguous statute even where the court concluded that a different interpretation was better supported. As a result, Chevron empowered and encouraged agencies, including the U.S. Department of the Treasury and the Internal Revenue Service, IRS, to promulgate regulations based on statutory interpretations favorable to the agency's goals. So long as these interpretations did not stray too far from the bounds of reason, the regulations would often survive under Chevron. By ending the Chevron doctrine, Loper Bright has created new opportunities for taxpayers to challenge federal tax regulations. While taxpayers have long challenged federal tax regulations, particularly after the Tax Cuts and Jobs Act of 2017, Chevron's deferential regime hampered many challenges to tax regulations because where there was statutory ambiguity or silence, courts generally deferred to agency interpretations. Loper Bright has evened the playing field between taxpayers and agencies because now both must convince courts that their interpretation of the statute is the best interpretation. For practical purposes, that means challenges to some regulations that would have failed in the Chevron era may now succeed after Loper Bright. Challenges that failed in the Chevron era may be worth re-examining. Challenges that were not worth pursuing before Loper Bright may be worth pursuing now given the increased likelihood of success. In depth. Whirlpool, a case study of Chevron in action. The Chevron doctrine has often served to advance the IRS's interests against taxpayers. For example, Chevron played a major role in the U.S. tax court's decision in Whirlpool Financial Corporation v. Commissioner 154 TC 142, 2020. The tax court relied on Chevron to reject Whirlpool's challenge to the manufacturing branch rule in Treasury Regulation Section 1.954-3, b. 1, 2. The tax court's decision was ultimately upheld by the U.S. Court of Appeals for the Sixth Circuit on different grounds. Employing Chevron's two-step process, the tax court first asked whether Internal Revenue Code, Section 954(d)(2), is ambiguous or silent on the distinction between manufacturing and sales branches. The tax court answered affirmatively, 954(d)(2) could plausibly envision regulations dealing with any sort of branch, and there is nothing in the statute that prevents the Secretary from prescribing regulations that also address manufacturing branches, and then turn to Chevron's second step, asking whether the Treasury regulation is a reasonable interpretation of the statute. In a brief analysis, the tax court, as courts often did, deferred to Treasury and again answered affirmatively. In a final paragraph that underlined the chevron, framework's looseness, the tax court held for the IRS because whether Section 954(d)(2) is viewed as ambiguous or silent, the regulations are a reasonable interpretation of the statute, which is to say that the statute does not unambiguously foreclose the interpretation set forth in the regulations. Not unambiguously foreclosed is a low bar, but Loper-Bright has raised it. Without the Chevron doctrine, courts can and must employ all traditional tools of statutory interpretation to determine the best interpretation of a statute, regardless of whether the statute is ambiguous or what the IRS's own views are. Loper-Bright scope, implicit and express delegations. Loper-Bright overruled Chevron because the Supreme Court rejected the notion that when U.S. Congress passes an ambiguous or incomplete statute, it intends that agencies will fill in the gaps. On the contrary, the Supreme Court held that when Congress is silent about an agency's role in a given statute, it is not implicitly delegating interpretive authority to the agency. Instead, that authority falls to the courts.
Now I'm gonna stop right there. Now, did y'all understand that right here? That what happened, the criminal U.S. Congress in the House and the Senate, including in your state, where you got the state representative and state senator, and when you got the city councilor and the county commissioner, what they'll do, what they think they slick, will pass a law that's silent, ambiguous, and vague in law. What that means, they leave loophole for a third party, a private contractor to come in and fill in the gap and to interpret a law that may similar to be a statutory law, whether it's on federal side, state side, or county side, or the city side and everything. Now, I'm gonna explain to you what it was said that Congress cannot dedicate any authority right here. The Supreme Court shut this down by saying they cannot dedicate their interpretation to an agency, where agency is not legal lawful as a judge, nor it don't have the power as a jury. Nowhere the statutory, where federal, state, or county law or city law that passed by an elected official, it's up to the court, where the people demand a judge or the people demand a jury, a trial by jury. See what I'm saying? So in other words, if a foreign agency like IRS or the FBI or the ATF or the EPA or Department of Labor or the Federal Trade Commission, whoever these so-called agencies is, trying to interpret a missing law or a blank or a confused statutory law that does not make sense, but they come in there and make ruling, and make a policy rule and make a regulation rule or make a manual rule that somewhat kind of relate to it but not relate to it. Here's an example right here. Here you go. I'm gonna show you something right here. I want everybody to see this real quick. In other words, according to that thing y'all just heard, right? The phrase lack, all right, the phrase means lack sustainable ruling or even the rulemaking authority, often referred to a situation where an agency or an organization does not have the legal power to create rule that have the force of a law. So in other words, when the police officer pull you over, he is not an elected official. So in other words, when he, you know what I'm saying? In other words, he is trying to make a rule on the side of the road. So why he pull you over? In other words, the first thing you want to ask the officer, Is this statutory state law, or is this regulation from your police department, or if this is a manual policy rule from your police department? You know what I'm saying? Which one it is? Guess what? If it's statutory, then we go on statutory law. That's elected, you know what I'm saying? Passed by the elected official and signed by the governor of the state or by the president of the United States. See what I'm saying? No word. If they use regulation rule, policy rule, and the manual rule of their police department, guess what? You use motion to dismiss. You see what I'm saying? Now you're being interested. I'm gonna show you something. Now, you see it right here. I'm not saying that. It's right here. Here, go look. The phrase lack, you know what I'm saying? It lacks sustainable rule-making authority, often referred to a situation where a police officer, or IRS, or a ATF, or FBI, or CIA, or the Department of Labor, whoever the agency is, Child Protective Agency, or an organization does not have the legal, you hear that? Does not have the legal power to create rules that have the force of a law. This can be significant limitation, especially for a regulatory body, these so-called foreign agents. You see, that's why I got my complaint based on. My complaint is based on June 27th court case by SEC versus Germany, and it's based on June 28th, Chevron Defron, based on local fishery, something like that, versus Ramonio, and based on another one too. So nowhere I put all the wonderful things in there where I mentioned the cold case. I mentioned so many good things that it's beautiful. But now you see right here, right? Now I go back over here again. We're gonna look at this one more time. Right back here. Yeah, right here we go. Now you see it, right? Right here where it said, right? Now I want you to make sure you understand it. Now we're gonna finish. We're gonna finish this up. Here we go.
The Code, however, often expressly delegates regulatory authority to Treasury, either through the general grant of regulatory authority in Section 7805A or through specific grants in individual code sections. For example, Section 1061F instructs that he secretary shall issue such regulations as necessary or appropriate to carry out the purposes of this section, and Section 59A states that the secretary shall prescribe regulations necessary to prevent the avoidance of the purposes of this section.
Now I'm gonna stop there right there. Now, does anybody remember the U.S. Treasury Department or Department of U.S. Treasury before Homeland Security? Remember this, the U.S. Treasury, all departments fall under the U.S. Treasury Department. In other words, you had the FBI fall out of the U.S. Treasury Department. You had the Border Patrol, the Coast Guard. You had the Federal Wildlife fall out of the you know what I'm saying, fall out of the fall out of the Department of Treasury, right? All these agents, all these AC fall out of the Department of U.S. Treasury. The U.S. Treasury is the one that's supposed to make the law for the so-called AC, including the IRS, right? They want supposed to make the law. Now, what happened, because that fraud 9/11, the fraud criminal in Congress, and the fraud of George Bush Jr., they created a Homeland Security, meaning, in other words, the U.S. Treasury Department is no longer the head household of all the agencies. All the other agencies fall out of the now who? The Homeland Security. We ain't supposed to have Homeland Security. You're supposed to have the U.S. Treasury Department over all these so-called agencies, these foreign agencies. These foreign agencies supposed to come to the U.S. Treasury, and the U.S. Treasury supposed to make the regulation, right? You know what I'm saying? They supposed to make the regulation. I'm gonna show you something right here. I'm gonna show you something so people understand. You know what I'm saying? Cause right here, you never had. You know what I'm saying? The only department I know that had jurisdiction over all these so-called agencies was the U.S. Treasury Department before that before that crap, that fraud 9/11. You know, now we got Homeland Security, a fraud. Here we go, right here, 26 USC Code 7805 Rules and Regulation. It's right here. A self, authorization. Here we go. Here you go. Organization right here. Here you go. A step where such authority is expressed given by this title to any person other than an officer or employee of the Treasury Department. The Treasury shall prescribe all needful rules, regulations for enforcement of this title, including all rules and regulations as may be necessary by reason of any alternative of law in relationship to internal revenue. All right then. So nowhere. Why the IRS sending you a letter? Why the IRS said you need to comply? Why the IRS, IRS tell you that you need to have a phone, administrative hearing. You know what I'm saying? Administrative hearing over the phone. See, Chevron definitely also killed administrative law. It also killed, destroyed the so-called administrative court. It also destroyed administrative hearing over the phone or meet in person, like Social Security Administrative hearing or Social Security Administrative Court. Any any foreign agency claimed to be federal agency, they all have what we call administrative hearing and administrative court. Traffic court is administrative court. It's not real court. Your small claim court supposed to handle traffic. You know what I'm saying? Not no traffic court. That's why every county supposed to have a small claim court to handle traffic. Divorce court, divorce court, and family court is a administrative court. It's not real court. It's an administrative court. And what it is, it's a foreign court. It's an administrative court. It's not Article 1. It's not Article 2. It's not Article 3. It's not Article 4. It's just a foreign court. I'm tired of people always saying that this is an Article 1, a Article 1. No, your Article 1 is your legislation, man. Y'all need to get that fact straight. Your Article 1 is a legislation that make law, pass bill, vote on bill, on federal and state and county and local city area. That is Article 1. There's no such thing Article 1 court. There's no such thing Article 1 court. There's no such thing Article 2 court. There's only one court. It's called Article 3, where you got the judge and the jury. On the federal, you got a judge and a jury. On the state district court, and you have the county that county court known as small claim court. You know what I'm saying? That have a judge and a jury. A traffic court is not a Article 3 court. It's an administrative court. It's a foreign court. It's a third party. A family court, divorce court, is a administrative court. That's what it is. It's a foreign court. You know, go to the Social Security Administrative Court. Again, all these so-called agencies, they have a code. Put it like this: if a federal agency and a state agency and a city agency and a county agency have a administrative hearing or administrative court inside their building, then you know you're walking into a foreign corporation. That's what you're walking into. You're not walking into an Article 1. There's no such Article 1 for these people. There's no Article 2. There's no Article 3. So I want you to get that straight. You're walking into a foreign. That's why I made that complaint, to show you something. If you want this complaint, I can email it to you. You know what I'm saying? It's nice and good and clean. You know what I'm saying? I could do the complaint myself. No worry. I'd rather do the complaint for you and put in the right place for you. But right here, so nowhere when the IRS said, hey, we wanna you to redo your tax form. Hold up, you don't have no authorization. Or the US Treasury. The US Treasury on it right here. And guess what? And also what? Remember this? Also what? They lack sustained rule-making authority, often referred to a situation where an IRS, I'm gonna use this right here, an IRS agency or organization does not have the legal power to create rules that have the force of a law. You know what I'm saying? Like a police officer pull you over, does not have the legal power to create, or you know what I'm saying, have the force of a law. You see what I'm saying? Right here. Now we're gonna go keep it moving real quick. You know, so hold on. Now I want everybody to look at this. You know what I'm saying? Hold on. Let me see. Here we go. I want everybody to look at this real quick. Screenshot this, read this right here. Screenshot and read this. You know, because I don't want to stay too long on these things. You know, I'm kind of getting tired of it. You know, so I don't want to stay too long on this. But here we go. You know, we're gonna keep it moving real quick. Now I want everybody to look at this right here. Say government contract insight, but also, you know, you might want to Google this right here. The end of Chevron doctrine and what it means for False Claim Act. False Claim Act litigation. Again, what I show you is what I put in my complaint. What I show you, I put in my complaint. A sample of the complaint. Now we're gonna read this real quick.
The end of Chevron deference. What it means for False Claims Act litigation. By J. Alex Ward and Victoria Dalcourt Engel. Under the Supreme Court's decision in Chevron USA Incorporated v. Natural Resources Defense Council Incorporated for 167 U.S. 837, 1984, for decades courts have sometimes been required to defer to permissible agency interpretations of ambiguities in statutes those agencies administer, even when a reviewing court reads the statute differently. This is known as Chevron deference, or the Chevron doctrine. Loper Bright enters. V. Raimondo, 603 U.S. __, 2024 WL 320-8360 at *16, June 28, 2024. Last month, the U.S. Supreme Court overruled Chevron and held that courts may not defer to agency interpretation of the law simply because a statute is ambiguous. ID at *62. The court made it clear that courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority, as the Administrative Procedure Act, APA, requires. ID at *61-62. The APA was enacted as a check upon administrators whose zeal might otherwise have carried them to excesses not contemplated in legislation creating their offices. ID at *32. The court found that Chevron deference cannot be squared with the APA, which specifies that courts, not agencies, will decide all relevant questions of law and set aside agency action inconsistent with the law as the courts interpret it. ID at *38. A detailed overview of the Supreme Court's decision in Loper can be found on our website, and another article discussing the potential impacts of the Supreme Court's decision on government contractors is available on our Government Contracts Insights blog. This article discusses the potential impacts the fall of the Chevron doctrine may have on False Claims Act, FCA, litigation. In short, the end of the Chevron doctrine may create situations in which it is easier to defend against FCA cases based on violation of a regulation. Last year in United States ex rel. Schuette v. SuperValu, Inc., 598 U.S. 739, 2023, the Supreme Court determined that a defendant's contemporaneous subjective beliefs about a legal requirement matter, which made it harder to win a motion to dismiss on the ground that the requirement was unclear or open to more than one interpretation, i.e., the objective reasonableness, or clever lawyer, defense. The Supreme Court may now have revived a similar, though not exactly the same, defense through the back door, allowing a defendant to argue that a regulation underlying an FCA case is contrary to, or unsupported by, the governing statute. For example,
now I'm gonna stop right here real quick. I'm gonna show you something now. You saw that motion dismiss right here? Motion to dismiss, right? Now, why the guy say motion dismiss? Now, When y'all in that courtroom, most of y'all would challenge jurisdiction on skin color, whatever that's supposed to be. You challenge Article 1, is this Article 1, Article 2? No, man, it's like this. Most of the time, I'm going to say like this, 99% of the time, you in court based on the third party or the so-called foreign agency known as police department, IRS, ATF, the EPA, the OSHA, the Board of Education, Department of Labor. You know what I'm saying? You were in there uh, against the child protective agency, child support, whoever. You know what I'm saying? They break you in that court and they break their law in there when they should be using the statutory law. In other words, if it's federal statute law, then why are you telling the judge or the jury that, hey, according to our policy rule, according to our regulation rule, according to our manual rule, he owe us this or he violated our law. This way you use the motion to dismiss, because that law does not reflect what the elected official statute law is, or the federal or the state. That is not the state statute law. So in other words, you use the motion to dismiss because they're using a what? A law they may sound law, but it's not law. You remember this? Look, here go that motion to dismiss, right? See, this guy very smart. I like this guy right here. This guy is very, very smart. This guy is so smart. Here you go. I'm gonna show you why he was so smart and why he used the motion to dismiss. I'm gonna show y'all something before we go back to reading again. Again. Remember I told you regulation rule, policy rule, and manual rule. These so-called government agencies, these so-called federal, state agencies, these so-called county agencies. No word. Most time, people lose money, people get convicted, people go to jail, people lose their stuff, whatever, based on mostly policy, rule, regulation rule, and most time manual rule. These so-called administrative rules. No word, these are administrative laws. The, the Supreme Court shut that down now. No word, no more administrate outside the court. If you want to break this person in, you go in front of a judge, you go in front of a jury. No more. No more of this so-called administrative law. Because that will hurt people right now at traffic stop, red light, whatever you want to call it, child support, all these so-called dunning letters by these so-called agencies. Y'all been hurt by administrative law. You know what I'm saying? Y'all have not been hurt by statutory law. Y'all been hurt by administrative law. And here we go again. The motion dismissed. Here we go. This guy did a motion dismissed based on what? Lack sustainable rule-making authority, often referred to a situation where an agency or organization does not have the legal power to create rules that have the force of a law. This can be significant limitation, especially for a regulatory body. Now you see why he used that motion dismiss. Now we're gonna find out how that motion dismiss supposed to work. You know what I'm saying? See right here, y'all supposed to learn how to use that motion dismiss against these people. See my complaint? It had that right there in there. That the IRS had what? Lack of rulemaking authority. No delegation of authority because he does not have a file. Does not, does not have a franchise charter with the state of Texas. And also motion for discovery against the U.S. Attorney. You know what I'm saying? I'm at the U.S. Attorney. Hey, does he have an oath bound with you that you represent him on this case? Boom. You know what I'm saying? That's how you're supposed to do it. You know what I'm saying? You're supposed to do that against the FBI, the ATL, whoever. You know what I'm saying? If a U.S. attorney represents the third party federal agency, you're supposed to tell them, say you the U.S. attorney, please, out of motion discovery, I'm questioning the court to order the U.S. attorney assistant to give me the file and oath and a charter for this person that what I'm saying, state a claim on me. Bam, right there, it's on the record, right there, it's on the record. Here you go. Now we're gonna finish reading this real quick. I'm gonna show you why the motion to dismiss works. See that motion to dismiss? You know, we're gonna find out what that motion to dismiss is about.
Example, if an FCA defendant is accused of a regulatory violation in which its alleged conduct does not violate the underlying statute but does violate an implementing regulation, the defendant might contend the regulation is inconsistent with the statute. In that scenario, the defendant could move to dismiss on the ground that, even if the facts are as alleged, they do not support a legal violation. Under Loper, a court would have more latitude to consider that argument. Unlike the objective reasonableness defense the Supreme Court rejected in Schuette, which focused on the scienter element of an FCA claim, this new avenue would focus on the falsity element, arguing that it is not false or fraudulent to violate an unlawful regulation.
Now, see right here. See, this was before the Chevron death for June 28th. It was like last year, 2023 or 2022, right? But now, because of, you know what I'm saying, now because of June 28th, now the federal court realized, okay, we cannot take the word of a federal agency no more. We have the power out of the what? Article 3. What Article 3 is? Article 3 is who? The judge and the jury. Only the judge can interpret it. Only a judge can interpret the statute of a law. Say like all these so-called crappy laws that Congress passed, never, you know what I'm saying, never read the law, but they always vote on it, but they don't read it, right? So the law becomes ambiguous, either ambiguous, it becomes vague, it becomes silent, right? So the, you know what the law is not clear. And what happened, they, you know what I'm saying, look, so in other words, they try to be slick by what? Authorize or delegate it to a third party, a foreign agency. These foreign agencies called known as federal agency on the state side. These are state agencies, right? Again, they're foreign agency. On the county and city side, county agency and city agency, right? So in other words, they're not part of the elected official government. They're just third party contractor going to fill in the missing blank. It's not their duty to fill in the missing blank. You know what I'm saying? It's not their duty. Either statutory law, what it says, or give me the motion to dismiss based on, you know, inconsistent with the statutory law. See right here, this is how you use your motion to dismiss. Because see right here, this guy did a motion to dismiss based on what? Right here, I'm going to show you. Because of regulation by the agency. The agency brought in regulation claim against the president. They didn't brought in the statutory law by the congressman. They brought statutory law. In other words, they brought an in-house law, a foreign law into court. They did not brought in the U.S. Constitution. They did not brought in the U.S. federal law. They brought in foreign law. Regulation is foreign. Policy manual is foreign, like the IRS manual, the FBI manual, the police department manual, the police department policy, the FBI policy, the EPA policy, the ocean policy, the Department of Labor policy. You know, these so-called wonderful crappy AC, like the you know, like the TSA, you know what I'm saying, at the airport, policy, the manual and all that stuff, where people are grabbed and go in the back room. That's administrative. That's outside the court. Hold up. You can't bring me back in that room. No, you need to bring me to the nearest court right now. You know what I'm saying? And please don't use your regulation rule. Please don't use your policy rule. Please don't use your manual rule to detain me. Use the statutory law. Make sure the statutory law is clear. Now, I'm going to tell the court, I've been itching. I've been itching. And right here, how I've been itching, here we go. Right here, I'm going to show you something. I'm going to see something. Yeah, here we go. Right here. Here we go. Right here. I've been itching. And what that itching is? Fall claim. Fall claim. Fall claim. Y'all need to look this up, you know. Like I said, you know, if y'all want to do one-on-one with me, I show you how to do this real quick. But see right here, fall claim. Fall claim right there. See what I'm saying? No word. If you've been injured by the, by the so-called, like, lack of rule making, by these so-called agencies, and they make a claim against you, but they not using statutory law, but that's been elected by the official on federal, state, and city side, county side, guess what? Now you getting with false claim, false claim, false claim right here. But we're gonna keep on moving real quick, cause I don't want to stay on it too long. And right here, see right here, I want everybody to see what this is right here. The end of Chevron, a different, what it means for a false claim act litigation. I got that in my complaint. See it right there? I mean, you can use that for driver license and all that crap, man. You can use it for everything. Here you go. See right here? And right here, look at that. This is so beautiful. We're going to finish this up real quick.
Before Chevron's undoing, deference to agency interpretations of statutes may have given relators and the federal government a leg up in FCA cases, while defendants faced an uphill battle against years of agency rulemaking and a thumb on the scale in favor of agency interpretations. Now, savvy defense attorneys may look for potential daylight between a statute and the regulation a defendant is accused of violating.
See how
Share
simple that is? See how simple that is? See what I'm saying? No word, no word, no word. If they bring in policy rule, manual rule, and regulation rule that outside the statutory that was passed by the House and Senate, then you got a motion to dismiss. Now you got a false claim. You know what I'm saying? Now you can use this right here. Remember I show y'all something? I'm going to show you something real quick. Guess what? Now you can use this right here. Now you can use this right here. Here you go. You can use this right here. You can use this right here. And people, I want everybody to look this up. See right here? False, misleading representation. Right here. 1, A, B, and 4 and 5. You need to look that up. You know what I'm saying? I can tell you what that is, but, you know what I'm saying? I want you to see that. That's the reason why I put this right here. No way, you know what I'm saying? Look, you know what I'm saying? Look, you use it for a DUI. You know what I'm saying? Look, if they pull you over for DUI, if they make an arrest on you, again, misleading false, right? Misleading false. Again, if you get a letter from a child support agency, or I say like a child support agency, say something like your child cut up, right? A little small cut up, you know what I'm saying? He had fun, all stuff, acting wild and everything, right? All of a sudden, somebody called a child agency on your child for fighting, right? All of a sudden, the child agency comes to your home and take your child. Well, guess what? False leading and you know what I'm saying? False and misleading, you know what I'm saying? You can use this right here against them. You can use this against the FBI. You know what I'm saying? You can use this against the ATF. You know what I'm saying? Any form, any document, any paper, already you can use against anybody. This is why I got this right here. 1, A, and B, and 4, 5. I want you to see that. You know what I'm saying? But I got it right here if you want to look at it. Now we're gonna, you know what I'm saying? We're gonna keep it moving real quick. I got some more, man. I got some good stuff right here. Yes, sir. Here we go. I got some good stuff. There you go. We got some good stuff right here. Let's see. Hold on. Here we go. I gotta see something real quick. All right, here we go. Right here. You know what I'm saying? Look, we're gonna go right here real quick. Now we're gonna look at this real quick. You know what I'm saying? Now we're gonna find out what this is all about. Now remember this. This right here, this is after June 28th. This is right here. This is on July 3rd. You know what I'm saying? So nowhere it's like 1 week after that famous case, Chevron Deference. You know what I'm saying? So we're gonna read this real quick, or we're gonna go let the computer read it. I want y'all to hear it clearly.
Texas federal court partially blocks FTC's non-compete ban. Related professionals: Gregory S. Bombard Justin K. Victor Galit Kirkut Jacob R. Dean. Capabilities: labor and offices. Offices: Boston, Atlanta, Philadelphia, New Jersey. Subscribe. Share. Multiple litigations concerning the Federal Trade Commission, FTC, ban on non-compete agreements are progressing. On July 3, 2024, The U.S. District Court for the Northern District of Texas granted a preliminary injunction in Ryan LLC v. FTC, temporarily halting the ban for the plaintiffs and certain plaintiff interveners, but declining to extend the injunction to non-parties. For now, the ruling is limited to the parties in the case, and the ban will take effect for other employers across the nation on September 4, 2024. That may change, however, as the court indicated it would issue a final ruling on or before August 30th, 2024. Potentially indicating the direction of the case, the court held that 1. Plaintiffs are likely to succeed on the merits that the FTC lacks substantive rulemaking authority with respect to unfair methods of competition, and 2. There is a substantial likelihood the rule is arbitrary and capricious because it is unreasonably overbroad without a reasonable explanation.
Now, I'm gonna stop that right there. So in other words, the FTC came in there, did not come with the statutory law that passed by Congress. Even though, most times y'all, we know this right here on federal side, when the House and the Senate in Washington D.C., they don't really read the bill that they want, they're gonna vote on. So what they'll do, they'll just vote yay or nay, right? And what they'll do, leave that up to what we call a foreign agency. Stop calling these people government. Stop calling these people part of the part of the government. You know what I'm saying? No, these are private contractors. These are third party. I treat them as third party. I look at them as third party. I don't look at them as not part of the United States. No, they're foreign. They always been foreign. It's like the police department in New Orleans, like the police department in Louisville, Texas, where I live at now. They are foreign, you know what I'm saying? They provide service for a fee. That's all they do. They provide service. No, right, they're a private contractor. That's all they is. Y'all need to stop calling these people government. You know, the only government is the people that you vote for. That's it. The people that you vote and put in office. That is government. Those one are not government. They are third-party contractor. Always consider that. Now, right here, FTC, the Federal Trade Commission, try to create a policy rule against this president. They try to create a regulation rule and a manual rule telling him that he needs to follow their so-called in-house foreign law, right? It's like what I already tell you, you need to comply. Comply to what? No, I don't think so. You don't. Wait a minute. Wait a minute. All the AC want you to do what? Voluntary comply. They ain't gonna never tell you this. All the AC, like the FBI, the police department, state trooper, like Michigan State Trooper, Texas State Trooper, California Highway Patrol, whoever, they want you voluntary comply. They want you voluntary comply. How I know this? Hold on. You know what I'm saying? Nowhere. It's known as voluntary compliance. They ain't gonna never tell you that, but I'm about to show you something. Here you go. Now, right here again, Federal Trade Commission lack sustainable rulemaking authority. No word. I can tell you what happened. No word. The FTC told Ryan LLC, according to our regulation, not statutory law by Congress, not statutory law. Remember that word, statutory by Congress? No word. They will tell this guy, hey, you cannot do this, according to our regulation and according to our manual. Uh-oh. Wait a minute. This way you use your motion to dismiss. Now you got a conflict between the true statute law versus a regulation rulemaking that lack enforcement. You know what I'm saying? Like what? Enforcement. It lack enforcement. Nowhere, they want him to voluntarily comply. Voluntarily comply. You see what I'm saying? They want them voluntarily comply. That's what they want them to do. Voluntarily comply. Hold on, I'm gonna show you something again. Voluntarily comply, right? But now you see, right? This was based on what? The regulation right here. The regulation. Let me see if we can find that regulation. That it was based on regulation, man. That's what it's really based on. That's why the court shut it down. This is beautiful, man. This is real beautiful. That's why I try to tell y'all. See right here, in my complaint, I got that in my complaint. We're gonna keep it moving real quick. But I want y'all to see this real quick. It's not me saying, it's what they said. We're gonna look at this real quick. All right, here we go. Non-compete, lack of authority. Yep. Here we go. You know what I'm saying? All right, hold on. I think we better go right here real quick. Uh-oh. No, no, no. Yeah, here we go. Right here, please. Yeah, I don't want to stay on here too long, but you saw my complaint, right? That whole complaint could be used against any so-called three-letter agency, whether federal, state, or city agency. You know what I'm saying? Or county agency. You can use that, but also, I got a motion to dismiss. You know what I'm saying? It said like you want to do a motion to dismiss. I got a motion to dismiss based on any so-called agency bring you to court. You know what I'm saying? And right here, the first thing you want to see if it's statutory or if they in-house rule. You know what I'm saying? Rulemaking like policy rule, regulation rule, or manual rule. Remember this. Your elected official only makes two laws. Oh, so I don't know why this thing's so slow. I don't know why this is so slow, man. Well, I don't know why it's slow, man, but you know what I'm saying? Hold on. I don't know why it's so slow. I tell you what, we're gonna go right here. I tell you what, it kind of slow. I don't know what's going on. I don't know why it's slow. Hold on. I don't know why it's slow. Oh, all right, here, yeah. Here we go. I'm sorry about that, y'all. Yeah, here we go. Yeah, we're gonna go real quick. Right here. Here we go. We're gonna go real quick. It's all
Supreme Court maintains OSHA's authority, declines Allstate's refractory LLC challenge. And YesBe Blogger, July 10th, 2024 current events. On July 2nd, 2024, the Supreme Court declined to hear a challenge by Ohio-based construction contractor Allstate's Refractory LLC, which could have significantly weakened the Occupational Safety and Health Administration, OSHA. The case, backed by Republican-led states and anti-regulatory groups, argued that Congress unconstitutionally delegated its legislative powers to the executive branch by granting OSHA the authority to set and enforce workplace standards. Background of the case. Allstate's Refractory LLC, a company providing furnace services to the glass, metal, and petrochemical industries, claimed that OSHA's authority to regulate workplace safety was an overreach of executive power. The challenge was supported by Justices Clarence Thomas and Neil Gorsuch, who publicly stated they would have taken up the case. Justice Thomas emphasized that evaluating the constitutionality of OSHA's authority was an undeniably important question worth addressing. Legal and political support. The company was represented by Don McGahn, former White House counsel under President Trump, and received backing from 23 Republican state attorneys general and various libertarian legal groups. These supporters aimed to curtail the administrative state following recent Supreme Court rulings that favored conservative and anti-regulatory positions. Supreme Court's decision. Despite the support from Justices Thomas and Gorsuch, the Supreme Court issued a brief order declining to hear the case, thereby upholding the lower court's decision to reject the challenge. This refusal maintains OSHA's current authority, but signals that the question of delegating legislative powers to federal agencies remains unresolved and could be subject to future legal challenges. Implications for workplace safety. The Supreme Court's decision to decline the case preserves the status quo, allowing OSHA to continue setting and enforcing workplace safety standards. However, the ongoing debate over the constitutionality of such delegations suggests that future challenges could arise, potentially impacting the stability of current workplace safety regulations. For now, OSHA's authority remains intact, ensuring continued protection for workers across various industries. Employers must continue to comply with established safety standards, and OSHA will maintain its role in safeguarding workplace environments.
Now, now,
OSHA
now, I'm gonna stop that right there real quick. Now, when that case was brought up, I think in July, I believe, in July, I believe, what happened, it was not done right. So Clarence Thomas and the other Chief Justice, they decided to decline it because it did not go to the proper channel yet. You know what I'm saying? It just kind of like went up a little bit faster. But what I was told that in 2025, it will be back on the table at the Supreme Court. But first, it got to go back to the lower court. Then it got to go through the appeal. See what I'm saying? No, it got to go through the lower court, and then they got to do the appeal. You know what I'm saying? No, the plaintiff got to go to the appeal, and then appeal to the federal, then the federal appeal, then if you cannot resolve it, then you take it to the U.S. Supreme Court. But it was not like a emergency. See what I'm saying? Cause already Clarence Town already gave you the Chevron deference, and also he gave the SEC versus SEC versus Jerkman. You know what I'm saying? So he gave them two powerful cases right there. You know what I'm saying? So nowhere Ocean just, you know what I'm saying? Ocean know this. Ocean know that this case gonna be brought back next year in 2025, and they know that their delegation authority about to be terminated. That includes all so-called third-party agency, known as federal agency, even state agency gonna be terminated. You know what I'm saying? Nowhere it just don't affect the federal agency. It's gonna affect the state agency. It's gonna affect the so-called city and county agency. Always remember that. Cause right now, Ocean just you know what I'm saying? Look, Ocean just got 1 year to live. That's all I'm gonna say like this. Ocean had 1 year to live before Supreme Court heard this case again. And trust me, I know that attorney, they gonna bring it right back up to the Supreme Court. But this time they gonna make sure it goes through the proper channel before it go back to the Supreme Court. See what I'm saying? So in other words, they on their last leg, y'all. These so-called unelected officials, you know what I'm saying, trying to make these so-called crazy laws. You know what I'm saying? These obnoxious laws. I'm gonna see some. Hold on. Now I'm gonna see if I can find this thing real quick. I'm gonna see if I can find this real quick. Let's see if I can find this real quick. Hold on. I really gotta find this, y'all, real quick. That's the case I'm trying to find real quick. If I can find it, I gotta find it. Oh, man. Let me see. I want this shit right here. Uh oh. Uh oh. I can't find it, y'all. I don't know what's going on. Man, I gotta find it. Hold up. Hold on. I'll tell you what I'm gonna do. I'm gonna do this real quick. Let's see if I can find this real quick. Hold on. SEC versus. There we go. I'm gonna go right here real quick. I can't find it. All right, here we go. We're gonna go right here real quick. I don't want to stay on this thing too long. Yeah, here we go. Yeah, it's gonna be right here. Yeah, I figured that's it right there. I figured that was it right there. Why is it? Man, this gotta be crazy. Man, why do that? All right, I'll tell you what, y'all. I'm gonna check it through one more time. Here we go. All right, here we go. Now we got. I don't know why it took so long to do that. All right, here we go. Now we're gonna go right here and do this real quick.
SEC v. Jarkissi, Supreme Court eliminates SEC v. Jarkissi, Supreme Court eliminates a significant agency enforcement tool. Broad implications, key takeaways. Written by Deborah Meshulam Whitney Cloud Andrea Guzman Jason Luis Alex Rivero. On June 27, 2024, the U.S. Supreme Court ruled that the Securities and Exchange Commission, SEC, cannot use its administrative courts, instead of Article III federal district courts, to decide securities fraud claims seeking civil penalties. In reaching its decision, the Supreme Court first concluded that the SEC's anti-fraud provisions replicate common law fraud.
Well, I'm gonna stop real quick because they skipped this right here. The court held that the Seventh Amendment entitled the defendant to a jury trial when the SEC seeks civil penalty against him for security fraud. So in other words, if you get a letter from a federal agency, the so-called third-party federal agency, the foreign agency, or you get a letter from the state agency, again, like the State Revenue Department, the State Trooper, or the State Child Support Agency, or a family court agency, you know what I'm saying? Whether it's on state county side, you know what I'm saying? If you get a letter from the wildlife park, the state wildlife park, or the county wildlife park saying that we caught you on camera with an overfishing and we want to fine you for $20, $30, $400, something like that. So in other words, this is, you know what I'm saying? Look, if it's civil penalty, you saying, guess what? We need to go to a court there. You cannot tell me I need to go to your administrative court or do administrative hearing like the IRS. Or, you know what I'm saying, with all these so-called federal aids. Even the police department, like when the police officer tell you, we need you to come to the police department so we can interview you. You know what I'm saying? So we can ask you questions. Man, I'm like this. That's administrative hearing. You ask me. Interrogation is administrative hearing. You know what I'm saying? Now they do administrative hearing or a administrative court inside that police department. Want to ask me where I was at that night. All that stuff. That's administrative hearing, man. Hold up, man. So are we bypassing the courtroom? Are we bypassing something? Again, pull you over for traffic stop. Uh-oh. You know what I'm saying? He's doing an administrative stop, right? You know what I'm saying? Ask that officer, are you doing an administrative stop? Uh-oh. Now you got him, right? Now you got him. Boom. Got him right there. You see what I'm saying? Again, that's how you supposed to tear their butt up, man. But I'm gonna keep this moving real quick. I ain't gonna be on here too long.
Fraud, thereby requiring that a jury hear such claims. Second, the court concluded that the public rights exception to a defendant's jury trial right did not apply to SEC anti-fraud claims because such claims did not fall within any of the distinctive areas involving governmental prerogatives where the Supreme Court has previously concluded that a matter may be resolved outside of an Article III court without a jury. Slip up at 7. The court declined to rule on two other constitutional challenges to the SEC's administrative process presented in the Jarkissi case. As discussed below, Jarkissi eliminates a significant SEC enforcement tool and also has broader implications for both the SEC and other administrative agencies who use administrative courts as part of their enforcement arsenals.
That's right. Like the
Background.
police department.
Prior to 2010, under relevant securities laws, the SEC was authorized to seek civil penalties for securities fraud only in Article III courts, where defendants have the right to a jury trial. In 2010, Congress passed the Dodd-Frank Act, which expanded the SEC's authority and allowed it to seek civil penalties for securities fraud in the agency's administrative courts. If the SEC chose to sue a defendant for securities fraud and seek penalties in an administrative proceeding, the defendant was no longer entitled to a jury trial. 1.
What? Woo! You hear that? Guess what? The Supreme Court killed that man. Cause right here, again, Congress is our enemy. These no good so-called dual citizenship congressmen on the House and Senate, even on state side. That word, according to everybody's state constitution, the original constitution, According to the U.S. Constitution, Article 1 said what? The House and Senate is the legislature. They shall pass bill and make law. You see what I'm saying? It didn't say a third party make law. They didn't say that third party could seek damage. They didn't say that. No, to seek damage, that's Article 3. That's Article 3. And Article 3 is what? The judge, elected official, or a judge on the federal side that's been appointed by the president. You know what I'm saying? That's who made, you know what I'm saying, a decision on the civil penalty, penalty. You know what I'm saying? In other words, third party agency cannot do that. So in other words, the Supreme Court took that power away. Not only did for them, for the SEC, also from what? FTC against the FBI, all them, you know what I'm saying? And matter of fact, look, ATF. That's right, the alcohol, tobacco, firearm explosive agency. Guess what? They are losing in Texas every day. They are losing their case every day in Texas, Louisiana, and Mississippi. Cause why? The judge is what? Taking a rule-making authority away. They don't have that power. In almost all the southern states, like Arkansas, Tennessee, North Carolina, South Carolina, Georgia, Florida, Alabama, Arkansas, Oklahoma, Missouri, these federal judges are taking the ATF power away. They are losing. Nowhere on the receiver, suppressor, you know what I'm saying? They are losing. So why? The federal court said you don't have the power to interpret the law and you don't have power to make the law. Remember I told y'all that? They like what? Rule making. No word. Policy rule is not law. Manual rule is not law. Regulation rule is not law. It's not forcible law. None of these not forcible law. The ATF firearm application, the Social Security application, is not forcible law. You know what I'm saying? The so-called IRS form, the IRS tax form, and all that stuff, it's not a forcible law. It's not law. You know what I'm saying? It may appear to be law. It's like the apple, plastic apple is not real apple. You know what I'm saying? A wax orange is not real orange because it looks like an orange, but it's not real orange. A banana glass is not real banana because it might be yellow and shaped like a banana in a glass, but it's not real banana. I'm gonna show you something. I'm gonna show you something real quick. Let me see if I can go right here real quick. If I can go right here real quick. Let's see. If I can go right here. Let's see if I can find something real quick. Here we go. I'm gonna show you something right here. I want everybody to see this real quick. I want everybody to see this real quick so you can see this. I hope it don't take too long. If not, we're gonna go back to the video. You want to see this, but I'm gonna show y'all something. Cause remember that not just the IRS, but it's, you know what I'm saying. You know what I'm saying. That this applies to everything. Watch it. I'm gonna show you something. Look, 601.602. Right here you go. Tax form and instruction. A tax form. Either tax return form and instruction. The Internal Revenue Service developed form. No word. Look. You heard? You see this right here? Say it. What? Here you go. I'm gonna say it one more time. I'm gonna do it real slow. The Internal Revenue Service developed form and instruction that explain the requirement of the Internal Revenue Code and regulation. Now, who do that, y'all? FBI do that, right? That way they develop these so-called policy rules. They develop the manual rule. They develop a regulation rule, right? Same as ATL, right? So ATL developed the so-called gun application for you to get a gun, right? Like the FBI, they developed these so-called gun applications. They developed it, right? They put regulation in there, right? They put manual in there, right? They put requirement in there, right? Come on. You know what I'm saying? Like, y'all see where I'm going with this, right? EPA developed instruction, right? They developed a form, right? But none of these things were developed by what? The elected official that you voted and put in office. You know what I'm saying? Don't worry, look. If the elected official did not develop the form or the instruction or the regulation or policy or the manual, guess what? It may sound like a law, but it's not enforceable law. You see what I'm saying? In other words, you do not have to comply. And the reason why I say you don't have to comply, guess what? The Attorney General tell you this right here. Here you go. And the instruction to help taxpayers comply with the law. But here we go. The tax system is based on voluntary compliance. Like the ATF is based on voluntary compliance. The FBI is based on the voluntary compliance. When you get pulled over by the police, city police, state police, sheriff's deputy, it's based on voluntary compliance. You know what I'm saying? Don't worry. Look, check this out. If they develop the manual, if they develop the policy rule, if they develop the regulation on how to do a traffic stop, but it's not based on the statutory law that you voted to be in the state office in your state or the federal. Guess what? It's based on what? Voluntary compliance. And according to this right here, I'm gonna show you something. Look at this, y'all. It's based on what? Voluntary compliance, right? So in other words, I want everybody to screenshot this. I want everybody to pay attention to this part right here. I want everybody to pay attention to this. Not this part right here, but I want everybody to pay attention to this right here. This applies to all the so-called third-party agencies, like federal agency, FBI. It's just like child support agency, right? You know what I'm saying? Look, let's switch it up right here. Say, look, the child support agency developed a form and a structure that explains the requirement of the child support code and regulation. The child support agency distributed the form and the structure to help deadbeat dad or deadbeat mama and wild out kid that always doing bad things with the law. What law? Your law, not the elected official law, not the true statutory law that was voted, you know what I'm saying, that voted by the House of Senate and signed by the president or by the governor. Now, here we go. The child support agency is based on what? Volunteer. The ATF system is based on what? Volunteer compliance. What? The FBI system is based on what? Volunteer compliance. The Federal Trade Commission system is based on what? Volunteer compliance. The SEC, right? The Security Exchange Commission system is based on what? Volunteer compliance. You see what I'm saying? No, well, look. All you gotta do is read this and put any federal agency name right here, like the New Orleans Police Department developed a form and instruction. How about this? How about this right here? The Department of Transportation, Missouri, developed a form and instruction that explains the requirement of the Department of Transportation, Missouri, code, I say, code and regulation. Again, see what I'm saying? All you gotta do is put wherever AC name right there and look at that. And come down right here and say it like this. Here you go, look. The the land I say, the land management bureau system is based on what? Volunteer compliance, man. Look at that, y'all. I made it so easy for y'all how to switch it up. You know what I'm saying? All this volunteer compliance, baby. Nowhere Congress didn't pass this. Congress didn't vote on this, so nowhere a third party tell you, hey man, look, we developed this, man, and we feel like we want to force this on you because it's not really the House and Senate law. So no way, we developed it and we're gonna make you comply to this law. But it's voluntary. We gonna tell you it's voluntary, but it's voluntary. It's like you know what I'm saying, like the FBI background check. You know what I'm saying? Look, know what the FBI might tell you, look, we need you to fill this out, right? But here you go, take this out. Look. The FBI, all right, let's check this out. The FBI developed a form and instruction that explains the requirement of the FBI background code and check and regulation. The FBI distributed the form and instruction to help help clean, help U.S. citizen or help a felony person or foreign agent to comply with the law. But, the FBI system is based on voluntary compliance. Same as the ATF. All you gotta do put different AC name right there and say it with the AC that's attacking you right now. See what I'm saying? Like the Animal Patrol. Say like the Dallas Animal, say look, say like the Dallas Department Animal Patrol develop form and instruction that explain the requirement of the animal code and regulation in Dallas County. The Dallas Animal Patrol distribute the form and instruction to help the pet owner to comply with the law. But 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 the animal control system is based on what? Voluntary and compliance. Voluntary compliance. People get killed on voluntary, you know what I'm saying? Or so-called fake law. You know what I'm saying? People get, you know what I'm saying? Look, people being locked up. You know what I'm saying? People being executed by these so-called foreign agencies. Again, you know what I'm saying? And we're gonna go right back here. You know what I'm saying? No word. Look, we're gonna go right here. Hold up, I'm gonna show you something. I'm gonna go right back right here again. I'm gonna go right back here. Hold on, I'm gonna go right back right here. Hold on, let's see that. But I can go right back. All right, there it's not. All right, well, look, we're gonna finish this up. But now you see, right? Here we go. Yeah, we're gonna finish this up real quick. Yeah. Now you see it, right? It's all about compliance.
In 2013, Jarkissi and the investment advisor, Patriot 28, were charged by the SEC with committing securities fraud. The SEC brought the enforcement action in its administrative court. After years of litigation, the SEC found Jarkissi and Patriot 28 liable for securities fraud and imposed a $300,000 civil penalty. Jarkissi and Patriot 28 sought review of the SEC's decision in the Fifth Circuit. As discussed in our prior alert, the Fifth Circuit vacated the SEC's decision and remanded for further proceedings consistent with its opinion. Jarkissi versus SEC, and the administrative proceeding deprived the petitioners of their Seventh Amendment right to a jury trial. Trial. Congress had unconstitutionally delegated legislative power to the SEC by failing to provide it with an intelligible principle by which to exercise the delegated power, and the statutory removal restrictions on SEC ALJs violate Article 2 of the Constitution. The Supreme Court granted the SEC's petition for certiorari on all three issues addressed by the Fifth Circuit, although the court ultimately decided only the first issue. The Supreme Court's decision. In reaching its decision that the SEC's use of its administrative court to adjudicate the case against Jarkissi and Patriot 28 violated their Seventh Amendment rights to a jury trial, the court engaged in a two-stage analysis. Whether the Seventh Amendment's right to trial by jury was implicated, and if so, whether Congress was permitted to assign the claims to agency adjudication without a jury trial under the public rights exception. The court's analysis of the right to a jury trial. In evaluating the first question, the court explained that the Seventh Amendment extends to any statutory claim that is legal in nature, rather than sounding inequity, even where those statutory claims are brought by the government. The court emphasized that to determine whether a suit is legal in nature, courts should consider the cause of action and the remedy it provides, with the latter being the more important consideration. The court readily concluded that the SEC's cause of action was legal in nature because its anti-fraud provisions replicated common law fraud.
Oh, see that? Hold on, I'm gonna go right
In
here.
evaluating the
Nah. Look at that, man. Nowhere. Look. Let's go back to this thing real quick. If we can find this real quick, we need to go right back here. You know what I'm saying? Look, we're gonna go right back. Hold up, we're gonna go right back. There we go. Replicate what? A so-called common law, aka the elected official statutory law. You see what I'm saying? Remember I told you voluntary compliance, right? I want everybody to look at this real quick again. Look at this real quick. Voluntary compliance. Here you go. Look, here you go. Again. Now, well, look. SEC, right? They brought penalties, right? But here's the problem. The SEC lack sustainable rule-making authority to what? Issue that type of fine against that so-called private person. This should be brought to the third Article 3 court. All right, often referred to a situation where an agency like an SEC or a organization does not have the legal power to create rule. Again, remember I told you that? Y'all saw it right here, right? Here you go. I'm going to go right back. To create what? Rule, develop a rule, develop a manual, develop a regulation, develop a code against a person. You see what I'm saying? Because they all based on what? Voluntary compliance to these so-called code, regulation, policy, and manual. You know what I'm saying? Nowhere they will never tell you this. You won't find this on the internet. They will never tell you that this is a voluntary compliance. When you get arrested by an officer, when the officer knock on your door and say, we got a warranty. Okay, show me the legal signature from the clerk. Remember this, warranty, not just by the judge, but also the county clerk got to certify that warranty too. You know what I'm saying? If the judge signed it, but the clerk did not sign it, the county clerk did not sign that warranty and everything, guess what? It's invalid. So no, it's voluntary compliance. You know what I'm saying? No, it's not really a law because the clerk did not sign it. You know what I'm saying? No, I'm gonna make a video on the county clerk and show y'all the same rule again. If a judge signed the document saying you're gonna do 10 years, but if that clerk did not certify that 10-year sentence, guess what? That 10 years is invalid. That guy or that girl could go home if that clerk did not sign it and stamp it and file it with a book number, page number, and stock number on that case. That person go home, man, because the clerk messed up. Again, this is voluntary, baby. Going to the SEC, that's voluntary. Again, here you go. Again, the SEC, that's right. The Securities Exchange Commission lacks sustainable rule-making authority, often referred to a situation where in an agency like the SEC, right, or an organization does not have the legal power to create rules that have the force of a law. This can be a significant limitation, especially for a regulatory body. What's a regulatory body? Third party, right? These so-called third party, like the FBI, ATF, the Environment Protection Agency, like the ocean, right? The so-called Department of Labor, the Social Security, the so-called Department State. You know what I'm saying? Uh, the so-called post office. You know what I'm saying? All these so-called third-party agencies, like the BLM. You know what I'm saying? Bureau Land Management, something like that. You know what I'm saying? All these so-called clowns, the so-called the TSA right at the airport, right? So I want everybody to understand, like the TSA, especially them, come with these so-called rule making, these so-called rule policies, these so-called rule code and all that stuff. You know what I'm saying? All these things is not compliable law. The only compliable law is the law that the Congress vote yea or nay. On the state side, yea or nay. On the city side, yea or nay by the city council. On the county side by the commission, yea or nay. Other than that, if there was no law voted on and signed by the president or by the governor or by the mayor in the city or by the president of the county, then those so-called development, you know what I'm saying, these so-called development laws by these third-party agencies are voluntary compliance. Voluntary compliance. Hold on. Now, you know what I'm saying? Look, we're gonna go to voluntary compliance real quick. We're gonna go to voluntary compliance. You know what I'm saying? We're gonna find out what a voluntary compliance is. Cause a lot of y'all get your head knocked out behind voluntary compliance, you know what I'm saying? But a lot of y'all don't know how to file suit. You know what I'm saying? Hold on. You know what I'm saying? Hold on. I'm make sure I got everything right. You know what I'm saying? I want to make sure everybody understands this, man. We're gonna get this right. We're gonna get this right. Hey, voluntary compliance definition. Here we go. You know what I'm saying? We're gonna find out what this means. Now, we're gonna look at this. Say voluntary compliance refers to the principle that the citizen will cooperate with with their government by filing honest and accuracy annual return. What? Oh, look at that, man. Look at it, look. You know what I'm saying? Look, when it's saying that a citizen will cooperate with their government, not with their government. You mean like a third party contract? Cooperate. You know what I'm saying? Look, we need to find out what the cooperate means. But let's see what the voluntary compliance is. Let's find out what that is, man. Cause like I said, this thing can work both ways. I want everybody to take a look at this, cause voluntary compliance refers to the principle that citizens will cooperate with their government by filing a honest and accuracy annual return. Meaning, no word, look, no word, look, no word, look, no word. They want you to snitch on yourself. They want you to tell what you got so they can rob you. You know what I'm saying? They want you to rob you. You know what I'm saying? They want you to actually, you know what I'm saying? No word, look, you know what I'm saying? Look, no word, you tell them what you have where everything should be private. You know what I'm saying? It should be private. You see what I'm saying? No word, look. We need to find out what corporation. Well, actually, I already know what it is, but I want everybody to look at that. You know what I'm saying? So people need to understand, man. Y'all need to stop volunteer compliance, man. Not just on tax return, but it could be for any agency. You know what I'm saying? It could be with any agency. That's right. Hold on. I'm gonna put this right here where there's an agency. I'm gonna put an agency right here. Here you go. Now we're gonna look at this right here. All right, here we go. Now we're gonna get a very good accuracy. You know what I'm saying? Now look. Now here we go. Now you know what I'm saying. Look, now we're gonna get a little better understanding. Cause see right here, they try to be slick. Now we're gonna get a little bit you know what I'm saying. Let's see something. Hold on. Let's go right here real quick. Here you go. Look, I want everybody to see this real quick. Hold on. There you go. There you go. Yeah, we're gonna look at this real quick. Here you go. The city shall mail a copy of determination of compliance to each original name in the warning. A voluntary compliance agreement, notice, and an order. Stop work, order. Voluntary compliance authority Authority A, whether the city determined that a code violation had occurred or in, or is occurring. The city shall reasonable effort to secure voluntary compliance from the person responsible for the code violation. See what I'm saying? No word. They want you to volunteer to comply with the law. They're not forcing you, but they just saying that hey, if you don't volunteer, we might do something to you. It's just like this. A guy walk into your business and say, look, we want you to pay a protection fee. No, well, look, we're gonna tell you, look, give us $500 every week. $500. No different than that case from Chevron there for Lova, Bright, Enterprise versus Raymond. You know what I'm saying? No word, no word. It was racketeer, it was extortion against that fisherman. You know what I'm saying? No word. A guy come in your business and say, look, I want $1,000 for protection fee. No word, you can volunteer comply to that $1,000 every week, or you could stand up and not pay that $1,000 voluntary compliance to that mob boss. You know what I'm saying? These people are mob. You know what I'm saying? Like the police officer pull your police officer asks you to do a alcohol test and all that stuff, or get out of the car, we can do a search and everything. No, no, That volunteer compliance. If you get out that car, that's volunteer compliance. You know what I'm saying? That's volunteer compliance. Second, guess what? Look, they violate, you know what I'm saying? They violate your Fourth Amendment, they violate your Fifth Amendment, and they violate your Seventh Amendment. You see what I'm saying? But guess what? You gotta learn how to take that to court. See right here, it tell you right here, all this volunteer. I worry about it, look at this. Matter of fact, I worry about it, Google this right here. Google this volunteer compliance agreements definition. When you do that, then you get a clear understanding. You get a clear understanding what this is here. I want everybody to Google that. But now we're gonna finish this up real quick. You know what I'm saying? We're gonna finish this up.
Evaluating the remedy sought, the court held that the statutory factors underpinning the civil penalty remedy, factors that included culpability, deterrence, and recidivism, aimed at punishing or deterring defendants rather than compensating victims. For those reasons, the SEC's civil penalty claims were legal in nature, and the defendants had a constitutional right to have the claims against them tried by a jury under the Seventh Amendment. The court's analysis of the public rights exception. In the second part of its analysis, the court turned to whether the SEC's securities fraud civil penalty claims could be decided by an ALJ under the narrow public rights exception, by which Congress may assign certain matters to an agency rather than a jury. The court stressed that generally matters concerning private rights may not be removed from Article III courts, and here, the SEC's civil penalty claims implicated the defendant's private rights. The court reiterated that Congress cannot conjure away the Seventh Amendment by mandating that traditional legal claims be taken to an administrative tribunal.
Now I'm gonna stop that right there. You see it? Now, see what happened when Congress or your state or your county or your city, when they make an ambiguous law that's not clear, that's not understandable, when they make a law that's silent and vague, guess what happened? They will sign the law they never read. They will sign it and vote on it and give it to the president or governor in the mayor or the county president to sign it. And when you know what I'm saying, when these people sign these so-called laws, guess what? They give it to a third party known as a federal agency, state agency, a county agency, and a city agency, right? They'll give it to them and let them fill it out. You know what I'm saying? Fill in the missing blank, fill in the missing piece, fill in the missing part to that so-called, you know what I'm saying, unconscionable law. You know what I'm saying? Ambiguous. You know what I'm saying? The law is not clear. You know what I'm saying? The law is not clear. So what happened, 1984, so what happened, the Supreme Court would tell us, all right, because we don't know what Congress really is saying in the so-called statutory law. So we'll let you determine or determine what the law really means. Because Congress did not give us a clear understanding. But not no more. If Congress cannot make the law clear no more, guess what? Now you got motion dismissed. You know what I'm saying? Now what, the law cannot be enforced. If Congress cannot make the law clear, then the law cannot be enforced. In other words, second, a third party cannot make a law that sounds like a law, but it's not enforceable as a law. See what I'm saying? They cannot do that no more. So now you understand what this is, right? And sometimes it all, you know what I'm saying? Also, it's what? It's a false claim by these so-called third-party agencies. Again, Now, you know what I'm saying? So right here, so I made it very clear for you. You know what I'm saying? I made it very clear. And here we go. Now we're gonna see what this really means. Now, see this right here, Fair Debt Collection Practice Act. Now you can use this uh you know what I'm saying? You know what I'm saying? You just get the share debit for taking your fingerprint and your mug shot. You know what I'm saying? Without your consent. You know what I'm saying? You know what I'm saying? Look, if a police officer drag you out of your car and write you know what I'm saying? Write a police report against you. You know what I'm saying? Like the police affidavit. You know what I'm saying? If a child agency or a child support people send you a letter, or you know what I'm saying, or IRS or whoever send a letter, or whoever issue a fine or any amount that you owe them, whatever, or say like a red light, say like you know, you got like a red light camera, right? All of a sudden you may have stayed ran the red light, right? All of a sudden that red light catch your license plate, and guess what? In 3 days they send you a letter. You know what I'm saying? Saying you owe us $200 for running the red light. Or you know what I'm saying, you take the taxi, you know what I'm saying, you take the toll road, right? And you go on toll road like Pennsylvania, right? Or Interstate 80, right? You know what I'm saying? Or 76, you go on toll road, right? All of a sudden you get a bill, you know, by mail. You know what I'm saying? You get a bill by mail. Again, they say that you owe us 90,000 for the toll. New Jersey, you owe us 90,000 for the toll. New York, you owe us 90,000 for the toll. Guess what? Guess what? Now they violate your Fourth Amendment, your Fifth Amendment, and they violate your Seventh Amendment. Because now, because that letter what they did, that's an administrative hearing. That is an administrative hearing. That way they tell you that this is a hearing that you owe us this. We determine what you owe us. Again, administrative, in other words, there's not supposed to be no administrative hearing. There's supposed to be no administrative court on this land. There's not supposed to be no administrative hearing, no administrative court on this land. The only thing you're supposed to have is a county, a small claim court in your county, and you're supposed to have a state court, district, and you're supposed to have a federal court. That's all you need on this land. You ain't supposed to have a divorce court. You ain't supposed to have a family court. You ain't supposed to have a child support court. You ain't supposed to have a Social Security Administrative court. You ain't supposed to have a DMV court. You ain't supposed to have no type of court. See what I'm saying? You ain't supposed to have a TSA administrative court. You know what I'm saying? You ain't supposed to have no FBI hearing. We ain't supposed to have no ATF hearing. We ain't supposed to have none of these so-called administrative hearing or no administrative court. Everything supposed to be small claim court, state district court, and the federal district court. That's it. That's all you need right there. Now I want everybody to see this right here, what this is. Right here. 15, section 1692, section 8, 807, false misrepresentation. 1A, B, and 4B. Now, we're gonna find out what that is, cause that's the reason why I got that there. Now we're gonna find out what that really means. No, well, look, if you get a ticket by a police officer, guess what? You can use that right there. You see what I'm saying? You see what I'm saying? No, where a police officer give you a warrant, and that warrant was not signed by the county clerk, even though the judge might sign it, but that warrant is still invalid. Now, we're gonna find out what that means. Here we go. Hold on, we're gonna go right here. Here we go. Y'all remember this? Here we go. We're gonna go right here to it. Here we go. What that say? False and misleading reputation, like the IRS form, like the ATF form. You know what I'm saying? The so-called background check by FBI. You know what I'm saying? The social. You know what I'm saying? You know what I'm saying? Whatever come in that mail, you can. You know what I'm saying? You can use this right here. It said what? A debt collector may not use any false, deceptive, or misleading representation or meaning in connection with the collection of any debt, like the red light camera, the toll camera. You know what I'm saying? That take your license plate picture and tell you how much you owe for the toll, the road that you took on the toll, without limit the general application of the foregoing, and the final conduct is a violation of this section. Uh-oh, that. Y'all remember the one? Here we go, right here. It said what? The Here we go. The false represented or the implication that the debt collector is voucher for, bound by, or affiliated with the United States or any state, including the use of any badge or uniform or face mask. Hello, police department. Hello, so-called Internal Revenue Service. Hello, ATL. Hello, child support agency. Hello, only third-party agency like the Federal Trade Commission. Hello, the Department of Labor. Hello, you know what I'm saying? Department of Education. Hello, the you know what I'm saying? The Michigan State Police, the Louisiana State Police. You know what I'm saying? Guess what? They all fall out of this thing. Now you see what I put that right there? Now we're gonna look at A and B. Here we go. We're gonna look at A and B. A and B right here. A and B and right here. They say the character and amount and legal status of any debt. The character. Any service rendered or compensation which may be lawfully received of any debt collector for the collector of a debt. And we're gonna look at 4, right? Here we go. The represent implication of the non-payment of any debt will be result in arrest and imprisonment of any person, seizure, garnishment, or attachment, sale, or any proper way, or any person unless such action is lawful and the debt collector or creditor intends to take such action. And the threat to take any action that cannot legally be taken or that is not intended to be taken. Now, y'all see what I just did? Now, well, look, you can use that against a fingerprint and a mug shot. You know what I'm saying? You can use that if the officer writes you a ticket for speeding. You know what I'm saying? Or not having a driver's license. Because remember that once he put that pen on that paper, it's false, misleading reputation. Nowhere, he doing a what? Administrative hearing. And also when he doing what? He lacked sustainable rule-making authority. He does not have a delegation of authority either. You know what I'm saying? Don't worry. He is creating a law that may sound like a law or close to a common law, but it's not forcible law. Do you understand why I put that right there? Now you understand why I put that there. You see what I'm saying? I want you to understand that. Again, we're going to go back and look at this real quick. Look at that. Cause of action. Right here. Fair debt collection. Again, this can be used for any legal document that's been mailed to you. Or somebody issued a document. You know what I'm saying? Like a parking meter. Say like, you know what I'm saying, you park on it, you know what I'm saying? Also the parking meter writes you a ticket, right? Or say like the toll company take your car, right? And tell you that you gotta pay the toll company $500 to get your car back. Again, that's false misleading. Again, you can use that. Say like the repo man. If the repo man take your car and said that I did not owe the bank the money, well, guess what? If the bank did not take you to court and got a judgment, guess what? Why did the repo man take your car? Because you didn't make a payment on the car or you 4 or 5 months behind on the car? Guess what? False and what? Misleading reputation. Guess what? You can go after the toll guy for that. And you can go after the bank that ordered that guy to take your car. You see what I'm saying? Guess what? Because right here, they're supposed to get a court order. Again, in-house rule. Again, this is an in-house rule. Rule making. Remember this? This is voluntary compliance. Again, this right here, this the number one that I made, you know what I'm saying? Everybody do anything different, but this what I did right here. I made this the first day as a violation. I made this the first day as a violation, fair debt collection. And the second violation I made, I'm gonna show you, you know what I'm saying? Here go the second violation right here. I made it so sweet, man, that everything it lined up perfect. I can use this for everything. You know what I'm saying? But the word gonna have to be changed, you know what I'm saying? Like the man, the street, and all that stuff, the time, the day, all that had to be changed. Look, the second violation right here, registered foreign agent, propaganda act. You know what I'm saying? The reason why I got them as a foreign agent, remember this, they're not part of the Constitution. They're not part of the state constitution. They're not part of the state and the federal constitution. Remember this, these people are third party contractors. That's why I put that there. You know what I'm saying? If y'all really want to see what I put on here, man, like I said, hit me up, man. Hey, I'll give it to you. You know what I'm saying? Show you how this thing works. It go third violation. And you know what I'm saying? Sure. You know what I'm saying? I can do it for you. I can tell you how to file it, and you know what I'm saying, where you pay your fee, and you know how to serve them. hmm Here you go. Look, the third violation: examination of their certification and appointment. You know what I'm saying? So, in other words, look, for them to force statute law, they're required to have a bond and oath and register with the state and with the federal. See, they supposed to, you know what I'm saying? They supposed to have that. See what I'm saying? Again, this is a sample I put right here. Now, I see what the fourth violation is. Government organization employee. You know what I'm saying? So, this week I put this right here. Now, let's read this real quick. The plaintiff alleged defendant willfully, intentionally, knowingly operate no position. You hear that? No tradition of office or tradition of public crime, and no traditional court order judgment from Article 3 judge or jury within what? District 26, or I like to say Federal District 26, Texas, U.S. House Representative Michael District. That's right. Michael is the congressman that this guy sent a letter to. And within the county, you know what I'm saying, within the county of then clerk office, meaning in other words, the clerk certified the so-called levy letter, right? They certified it. And you know what I'm saying? So they become third party in the suit, in the future suit, once this suit is over. Which harm plaintiff and alleged private civil penalty. You see what I'm saying? Now I put all the language that I show y'all from the SEC versus Jeremy and the Chevron doctrine, DEFRA. I show y'all all these things. I put all that in there where I mentioned the so-called case. You know what I'm saying? I put the good language in there, like this right here. Civil penalty, administrative, non-compliant, non-fact of law outside of the duty of Article 3 court with a judge or a jury. I mean, in other words, John Doe would enter by a administrative non-compliant laws. You know what I'm saying? And defendant ignored plaintiff affidavit request twice about defendant must have a written dedication of authority from who? Guess what? Because he sent that letter inside District 26, a federal District 26, House Representative Michael. Well, guess what? Michael is obligated to protect that district. I'm gonna tell y'all one more time. On the state side, if you get arrested, find out who the state representative for that district where you got arrested at or where you got a ticket at. You see what I'm saying? Find out who the state representative is because they are the trustee of that district. They are liable for all action in that district. Like on the federal side, Michael is Michael is responsible for that district. And right here, I would enter it. That way I suffer pain. I would enter it, right? John Doe suffer. John Doe have a hardship inside Federal District 26. The trustee is Michael, and he responsible. You know what I'm saying? He responsible for that action. Don't worry, no, he gonna be sued, compliment, or to operate out of the IRS commission, out of the public oath and public file for delay of record within addressing, plaintiff located, pursuing delegation of authority. 5 USC 302B12. That way, y'all need to look that up. You know, I won't go too long, but I put the law right there. And check this out. Here you go. Look. A plaintiff alleged that all relatives under the, here you go. Check this out. A plaintiff alleged that all relevant time under the 26 USC 78058 authorization only the Treasury has the authority to make rules and regulate the return revenue authorized by Congress, right? That's right. Now, wait up. Only the U.S. Treasury could make regulation rules. The IRS cannot make the rule. See what I'm saying? So right there, anything the IRS said, I'm gonna use the word motion to dismiss out of the Title 26 USC 78058. Organization on the U.S. Treasury. I'll shut them down anytime they keep open their mouth. I'm gonna shut them down and I'm asking the U.S. Attorney, motion for discovery, U.S. Attorney. Are you speaking on behalf of Michael Duggan? Yes, you will. Are you speaking on behalf of the FBI that busted me for gun? Are you speaking on ATL? for speaking because I had some weed, some alcohol, or speaking up for the DEA US US attorney. Good, yeah. I request you provide the oath and file right now because you are the legal authority on behalf of this agency. So you must give it to me right now. According to the law. Boom. Guess what? Guess what? We shut that whole case down. And guess what? I'm gonna get paid something. And here you go. Look at Fred Reed. The defendant to show here you go. The defendant to show Article 3 court judgment from judge or jury delegate authority before taking plaintiff asset in March 2024. Fail to maintain and fail to follow reasonable discovery to ensure maximum possible accuracy of plaintiff affidavit complaint. And the county clerk, you get the county clerk office occurring the account in question violate the GOEA. I know what that is. You know what I'm saying? And Title 5 USC 302 plaintiff alleged that defendant failed to conduct proper and lawful investigation into plaintiff affidavit. Meaning, in other words, they failed to do their job. I did my job. You know what I'm saying? Steve did his job. Michael did his job. Everybody who did their job did their job. John Doe, that. You know what I'm saying? Look right here. Here you go. Look. All action taken by the defendant. That's right. All action was taken by the defendant within Federal District 26, Texas, U.S. House District Michael, and Dent County Clerk Office, and where done with malfeasance, were done willfully, intentionally, knowingly, and were done with the either the desire to harm plaintiff and or with knowledge that their action were very likely harm plaintiff, or that their action were taken in violation of the GOEA. You know what I'm saying? As state law that knew or should have known that their actions were in regular disregard of the GOEA and the state law. Defendant and each of their act continued multiple willful non-compliance with the GOEA. Again, again, right here. All violation of GOA approximately called injury and damage was inflicted and set forth in this compliance under what? Title 28 USC 401, you get 204, you get 2041, A and B, time and consumer commencing action against the United States. Y'all need to see what that is, you know what I'm saying? Y'all need to see what that is. And guess what? That's why I asked the court for damage, you know what I'm saying? That the United States Republican plan to move this honorable court to demand either an order, a judgment, or action, money damage, punitive damage, and statutory damage against Michael Douglas. I'll just make up a name, within Federal District 26, and, the Congress District, you know what I'm saying? Elected boundary, false, false public record approved by the county clerk. Now, know where the county clerk certified the record, you know what I'm saying? Because remember, you cannot have a lien or levy without the clerk certify it. Always remember that. You cannot have a lien or levy or garnish way without that county clerk certify it. You cannot have a foreclosure without that county clerk certify it. You cannot have a car auction or a car report without that county clerk certify it. You know what I'm saying? But they all violate what? Amendment 7. Right, Amendment 7. What? Everything over $20, right? Oh. Go back to that. Together with such other further relief, you know what I'm saying? Further relief as the court may deem reasonable and other circumstance and further plan to demand jury trial on all issues. All right, here we go. Now, I'm going to show y'all something real quick. Now, I'm going to go back to this thing right here. I'm going to go back to this right here so y'all can see this. You know what I'm saying? We're going to go right back here. We're going to go right here. I'm going to show y'all something. I ain't going to go too long on this. I'm going to show you right here. Now, look at this right here. Why I got this at number 1. Now, here we go. Plaintiff is a what? National citizen of the United States. Or it could be the plaintiff is a citizen, a national citizen of the Temple Church Trust. You know what I'm saying? No word. It could be a trust, or you can just put your regular, your regular stuff as a U.S. citizen, whatever you want to put right there. Defendant is a foreign agent pursuant to the term defined by Title 22 USC 611 C1 and double O triple I. A defendant is a debt collector pursuant to the term defined by 15 USC 1692. Remember this, you know what I'm saying? So don't worry, you can make anybody a debt collector. Anybody that touch you, they're collecting your body. Anybody that put their hand on you, say you out of arrest, that's a debt collector. Anybody that say you're not going where we have to detain you, that's a debt collector. You see what I'm saying? Look, y'all see what I'm saying? You know what I'm saying? Look, if somebody said they from the child support agency, or they from the child protective agency, or they from the wildlife, and you know what I'm saying, they heard that you got 1,000 pounds of illegal fish. You know what I'm saying? And we want to see something. Don't worry, they are detaining you. Don't worry, they became a debt collector. You know what I'm saying? Again, if a police officer, you know what I'm saying, if the police officer take you to the sheriff office and get you out a patrol car and the sheriff collect your body and tell you that you gotta give it everything out of your pocket, that's a debt collector. Taking your phone, taking your wallet, taking your money, putting it all in a little a bracket, something like that. You know what I'm saying? And tell you, give me your hand so they can fingerprint you and take your picture. That's a debt collector. That sheriff definitely became a debt collector. You know what I'm saying? That sheriff department became a debt collector. If that prosecutor pick up your case and try to make a case on behalf of the police department, you know what I'm saying? Guess what? That prosecutor became a debt collector too. I'm gonna show you why I said that. Here we go. The defender is a debt collector, hard plaintiff since July 5th. So, no, I just made up a date, you know what I'm saying, of 2023 with the internal manual regulation and policy that are false and misconduct and misleading true fact. The IRS Form 668 notice of levy stolen money from plaintiff, paid settlement, stolen plaintiff, paid settlement from his employment pursuant to what? 15 U.S.C. 1692, Section 807. Y'all need to look at that. Again, I put that right there. Again, what I put right there, remember, you know what I'm saying? Look, remember I show y'all all them little case, you know what I'm saying, that people make an opinion about? Guess what? What I put right there, I put what? False and misconduct and misleading a true fact. So what's the false and what the misconduct is and what is the misleading you know what I'm saying, misleading of true fact. AK, they lack sustainable rule authority. They lack delegation of authority. Don't worry. They had developed this form called RS 668 11. Congress did not make that. I want everybody always try to tell you people need to do their tax return. No. I bet anybody $5,000 right now. I bet anybody $5,000 right now. The House and the Senate in Washington, D.C. did not make this up. They did not vote on this. They did not pass the Form 668, notice 11. So don't worry, we're going to go right here. We're going to go right here. Now, how did IRS Form right here? How did IRS Form 668, notice 11 was the, introduced to the public? So we're going to find out how this form became so-called law, but not really a forceful law. So in other words, they tell you right here, they they did what? Develop. They did what? They developed the form and the structure that explained the requirement. Whoa, explained the requirement of the Internal Revenue Code and regulation. The service distribute the form and instructions to help so-called taxpayers comply with the law. The tax system is based on what? Voluntary compliance. And the taxpayer complete and return the form with the payment of any tax that what? What did they say? And any tax that actually Now you understand? Now you understand the misleading, the false, you know what I'm saying? The misconduct, you know what I'm saying? Now you see why I put that right there? You know what I'm saying? Nowhere. I'm putting the June 27th in there. I'm putting the June 28th, and also I'm putting that so-called Alliance Regulatory thing. Where July 3rd. where the Supreme Court brought the case back. But I put all these things in there to show you where I mentioned the so-called Supreme Court case name. See what I'm saying? No, I put the key language in there. I put the key language, and here goes the key language right here. Here's the key language right here. The manual, regulation, and policy that are what? False and misconduct, misleading. Uh-oh. How about I put it right here? With the IRS, here you go, with the IRS manual, regulation, policy that are false and misconduct, misleading, true fact, right? So in other words, this is volunteer. First, I'll tell Judge, the IRS developed this. Call to my, you know what I'm saying, call to motion for, you know what I'm saying, look, call to you know what I'm saying, call to that motion to dismiss. The regulation does not fit the statutory law. Y'all remember that case? You know what I'm saying? Look, y'all remember that I showed y'all that the so-called motion to dismiss the regulation, the so-called, see right here, motion to dismiss what? The regulation, motion to dismiss what? Policy. Based on what? It's not a statutory law. So in other words, it may sound like a law, but it's not forcible law. See what I'm saying? It may sound like a law, but it's not really a law. Again, I go right here to right here. Plaintiff was harmed by the action of IRS 668 notice of levy from the defendant within the federal district 26, Texas, U.S. House Representative Michael under 15 U.S.C. 1692, and look up 7, y'all. It says false what? The false representation and implication that the consumer committed any crime or any conduct in order to what? Disgrace the consumer on a so-called tax expert interpretation of the what? Internal Revenue or Service Administrative Procedure self-law. So I put that right there. Say it's a self-interest, non-compliant. This is voluntary compliance. You know what I'm saying? No, but this is not the House or the Senate law by Congress. This is what? A so-called lack of authority to make a ruling maker. In other words, they made their own rule up against somebody. They made their own crazy rule up. And number 8 of this so-called right here is they communicate or threaten to communicate of any reason, credit, or information is known and which should known to be false, including failure to communicate that a dispute or debt is a dispute. Again, you can use this against the police department, the sheriff department, like the fingerprint, taking your, you know what I'm saying, taking your cell phone, searching in your pocket, you know what I'm saying? You got anything that gonna stick me, like you know what I'm saying? Like when they handcuff you and tell you like spread your leg and all that stuff, anything I put my hand in there, it's gonna hurt me, injure me. You know what I'm saying? You can use that right there. See what I'm saying? You can use that right there. You can use that right there. You get a letter from any agency like the toll booth or from the camera light. You know what I'm saying? The red light speeding camera. You know what I'm saying? Somebody send you a letter with that amount on there. Or child support agency said that this woman identified you as the daddy and you got to go to our court hearing or our administrative hearing. You know what I'm saying? That's what it is, administrative hearing. You know what I'm saying? In other words, you got to go to a family court, see if your child should be put in foster care. You see what I'm saying? You see what I'm saying? In other words, you can use this right there against these people. You see what I'm saying? You can use this against the state prosecutor. You can use it against the anybody, man. That's why I made that right there, man. That thing is universal, versatile. I like that law right there. That's right. I like that, man. Y'all need to look at the law where I put right there. See what I'm saying? Now you show, you know what I'm saying? Now you see I put the IRS form right there? Guess what? Look, I can put the police arrest, the police affidavit right there. You know what I'm saying? Because the police made a false, you know what I'm saying? False allegation on that police report, right? Also, the witness line, right? So, no, I can put, say, the witness lied on the police report and the police threatened me. You know what I'm saying? So I can put that right there too. You know what I'm saying? It doesn't have to be the IRA, it could be anybody. You know what I'm saying? It could be the ATF. Said that I lied on their phone. Well, guess what? Your phone is misleading. Your phone, you know what I'm saying? Look, your phone don't have no power. So no, I didn't mislead. So that way, look, if I put my name on there, but decide not to put the social security number on there, so that way, did I mislead you? Did I falsify? So that way, so that way, the social security is voluntary too. So that way, if I don't put my social security number on there, if I don't put yes or no, I've been convicted of a felony, I don't have to put that on there. Matter of fact, I don't have to fill out your application, your so-called FBI application to buy a gun. I don't need to put the, you know what I'm saying? I don't need to do no background check. Why should I do that? You know what I'm saying? When you don't have no rule making authority, no rule making delegation of authority, you don't have that power. You know what I'm saying? You don't have that power. You never had that power. You know what I'm saying? Everything is what? Voluntary compliance. Nowhere. Right now, I would tell the court. I would tell these so-called AC like the FBI, ATL, whoever, the land bureau, the wildlife, you know what I'm saying, the TSA, you know what I'm saying. I asked them, did you develop this? You know what I'm saying? Did you make the rules of the so-called development law thing that got me in court right now? Yes. Guess what? Motion dismissed. You know what I'm saying? Motion dismissed. Plus, I suffer. Right now, I tell the court, I suffer injury. I suffer damage. I'm asking the court to seek penalty and damage. You know what I'm saying? That's right. I'm seeking damage in that courtroom. I'm seeking damage, baby. Here we go again. Here we go right here. Again. Again, right here. Look at this right here. Defendant is a foreign agent. You know what I'm saying? Yeah, here we go. Defendant is a foreign agent, and the IRS Form 668 Notice of Levy Act went in under the violation of 1692-8079, the use of what? Distributor of any written communication with the similar is a false or represented to be document authorized. You know what I'm saying? Like, you can put like defendant is a foreign agent, is a private contract for the New Orleans Police Department, or you know the defense is a foreign agent, is a third party contractor for the Texas Highway Patrol. You see what I'm saying? Now where you can put anything right there that they so called Texas police affidavit is a violation of this word right here. That's right. You put the police affidavit right there. You know what I'm saying? You can put the police report right there. You can put the police report with the witness making a statement. You can put that right there. The use of script of written communication stimulate to a false representative. You know what I'm saying? That way they lie on their so-called made up paper, they so-called made up document that have no enforcement law. You know what I'm saying? Only the court could make the law. I mean, you know, interpret the law. You know what I'm saying? Only the court could interpret the law. Only the court could do that. They cannot do that. You know what I'm saying? See, right here again. Here we go. It authorized and issued and approved by any court. See what I'm saying? I put that right there. To be approved by what? Any court. No, what it tell you right here. This law tell you that it got to be approved by what? Any court or an agency of the United States or any state. Which create false impression. You know what I'm saying? False impression as to its source or you know authorization. I mean, yeah, authorization or approval or it a direct violation of the Seventh Amendment of the judge or trial by jury, man. That's right. There we go. Again, see what I'm saying? But this is what I want to show y'all. See what I'm saying? So I put all this right here, man, kind of give you an idea. Here you go. Again, let's see something real quick. Defender RF form, Defender form 668, notice of levy, use unfair practice to collect from the plaintiff on a false pretend contact plaintiff by cell phone. No word, look, if they contact you by phone, or by mail, whatever, or contact you by, you know what I'm saying, putting the lights on, you know what I'm saying, putting the red, blue lights on until you pull over, that, you know, this is a investigation stop. You know what I'm saying? All these are false pretense. Nowhere, nowhere, nowhere they develop develop regulation code and manual that, you know what I'm saying, sound like a law, but it's not really a law. It sounds forcible, but it's really not forcible. The only way it can be enforceable, or the court could interpret the statutes of the law by the elected official, what it mean and what it say. You cannot do that with a badge. Oh, you cannot do that as a tech, as an IRS. You cannot do that with as an ATL. You cannot do that as a lab, Bureau of Land Management, BLM, something like that. You cannot do that as Department of Labor. You cannot do that as OSHA. You cannot do none of that stuff. Only a judge could interpret a law by Congress. Only a state judge could interpret a statute law by the state. See what I'm saying? Only they could do that. These people cannot. So no way they give you false document, false misleading document. Here you go again. Contact Planet Employee Business by phone, by fax, the violation of the FDCPA 15 USC 16 2 F Section 808 unfair practice. Meaning, in other words, unfair practice get you out of your car. Unfair practice to tell you that you're not wearing the seatbelt or your light is not on or you got a busted tail light in the back of your car. You know what I'm saying? Or your child not wearing a seatbelt, stuff like that. You see what I'm saying? Or you hanging on a car with a couple friends, looting. You know what I'm saying? Something like that. Again, they cannot do that. These are unfair practice against you. These are unfair practice. You know what I'm saying? Again, I want everybody to see that, right? I, I don't want to stay too long, but yeah, that's too long now, man. That's 2 hours 20 minutes. Well, look at this, y'all. But I want everybody to see this real quick. Look at that. See right here? This can be used in any agency. I got everything lined up perfect. You can get damaged in a penalty damage against these people. This is a sample, baby. I'll show you what all this stuff is, but right now I'm about to shut it down 'cause I don't want to go too long on this video, man. I really don't, but I'm gonna make some more videos here. And remember this, y'all. Nothing cannot escape that county clerk recording office. If you look at my complaint right here, I mentioned the county clerk office. The county clerk office is responsible for the so-called IRS, for the ATF, the FBI, or any agency like Child Support Agency, Child Protective Agency, or the Traffic Light Forcer, or the Parking Forcer, or Parking Meter Forcer, Traffic Forcer, whatever. They're responsible for any agency they certify in, and they come after you. They're responsible for this. You know what I'm saying? Always remember that the county clerk is the most powerful people, man. The IRS know this. The IRS cannot bypass the county clerk office. Nobody cannot bypass the county clerk recording office and the clerk. They cannot bypass that. See what I'm saying? They cannot bypass that. Always remember that. Nobody cannot bypass the county clerk office. Not the judge, not the prosecutor. Nobody. Not the police department, not the sheriff, not the federal agency. Not even Congress, not the president. Nobody cannot bypass past the county clerk recording office. All right, y'all. I hope this give you a little leg up on this real quick. But I'm gonna make some more video, man. But it's been a while, man. I ain't made no video, but I want everybody to see this, yeah? All right, y'all. Peace and love. Boys out. Peace.